Cool. All right. From your side, there's a procurement. There was a procurement mandate. So what that means is a landlord went, found an agent and told the agent, I don't want you to manage the property. I simply want you to find me a tenant, right? Now, the agent went and found a tenant, placed the tenant, everything seemed okay, a deposit was paid. Now, the tenant, 2 weeks into the lease, decides to give notice. Now, we all know, we've spoken about it a million times, the Consumer Protection Act allows tenants to give early notice of cancellation, but that doesn't come without its own consequences. If they do an early notice of cancellation, they may also be liable for a cancellation penalty that is reasonable. The question here is, because I paid a procurement fee or commission to an estate agent, so that you often find is around 1 month worth of rental. So let's say the first month's rental went towards the agent's procurement commission. 2 weeks in, the guy cancels. Now, I want to ask, well, at the very least then, can I claim that from the deposit? Because now I need to go find a new tenant. And Nick, yeah, we spoke about what does the lease say, whether there's a minimum, a maximum, and how this amount factors in. So yeah, maybe give me your thoughts on that.
Perfect. So when we're talking about mandates, we first want to distinguish between two different types of mandates that exist. Okay, and it's important that we do. In this particular question, we've been asked about a procurement mandate. So procurement mandate is a mandate in terms of which an estate agent is mandated to find a tenant for a particular premises. And at that point, the mandate ends once a suitable tenant has been found for the property. We also then have a management mandate, and that is the type of mandate where an estate agent deals with the everyday rigmarole of the tenant occupying the particular property, invoicing, collection of rental, and dealing with issues on the particular property. Okay, and these two mandates can be distinguished. Okay, and for our estate agents out there, we suggest that you do actually distinguish what is your procurement mandate and what is your management mandate. Okay, because what happens often with estate agents is you guys will include these things together, and then there's a big question of what does it mean if a tenant cancels, like in this case, early. Luckily, we're not going to deal with that problem right now. I just want to keep the distinction between the two mandates. So in this question, we have a procurement mandate. The estate agent has done what they need to do. They have placed the tenant in occupation of the premises, and on that basis, they have earned their procurement mandate. Okay, remember the procurement mandate is payable by the landlord to the estate agent in the circumstances. So there's nothing wrong there. The estate agent has earned their procurement mandate. Now, once a tenant takes occupation of that particular premises, they obviously have certain rights which are afforded to them, both in terms of the written lease agreement that is signed between the parties, and importantly for the purposes of this question, in terms of the Consumer Protection Act, Section 14, which we deal with all the time. So once the tenant takes occupation of the premises, they are entitled at any point in that lease agreement to early cancellation of the lease agreement, provided that they give 20 business days notice. Now, our facts of this particular case are a bit odd because the tenant has spent less than 2 weeks in occupation of the premises, but notwithstanding, they are still entitled to a premature cancellation of the lease agreement, even on that short a time period, in terms of the Consumer Protection Act. That is a right that is afforded to them. So the question now is, what happens? Now, we know Section 14 of the Consumer Protection Act does have a kicker. So the tenant is entitled to cancel the lease agreement, absolutely, but they are subject to what is called a reasonable cancellation penalty. And as we have touched on in this forum before, what is reasonable depends on the facts of the particular case, okay, and the facts of every particular case. So this is why you've got to be very careful. We mentioned it before we came on today's proceedings. You've got to be very careful about writing in what is a reasonable cancellation penalty in terms of a lease agreement. There are a lot of lease agreements out there where they say reasonable cancellation is something like 2 months. Now, generally, that's going to be an okay provision, but these are the type of circumstances where that is actually going to hamper the landlord's rights rather than enforce them in the circumstances. Because if you have that written into your lease, you can only expect a 2-month cancellation penalty. But the facts of this particular case lend themselves to something a little bit more stringent than perhaps 2 months. Okay, so if you don't have something written into the lease agreement that says 2 months or gives a number that you could be expected, you could absolutely, in the circumstances, say, look, from the landlord's perspective, I am now subject to a procurement commission. I've had to pay my agent a procurement commission of whatever percentage or a month's rent or whatever the case is. And now I've had to pay that without actually getting any benefit out of the lease agreement, because unfortunately the tenant has cancelled with only 2 weeks in terms of the particular lease agreement. So not only am I entitled a loss of rental as a result of the premature cancellation of the lease agreement, I submit it's reasonable that I should also be entitled to return of my procurement commission in the circumstances, because I've had to pay a full procurement commission but only had 2 weeks of a tenant in the circumstances. And that is something that, again, what is reasonable is an up in the air question for all of these circumstances. But I can certainly say for facts like that, I think that it would be reasonable in the circumstances to say I should be able to get my procurement commission back as a result of the early cancellation of the lease agreement by the tenant, and you would essentially claim that from the tenants in the circumstances.
Thanks so much, Nick.
Perfect. Thank you, Bruno, and we will see you again next week.
Awesome. Have a great one.
Yes, sir. Bye.